Good morning, everyone. My name is Joaquin Esquivel, Chair of the State Water Resources Control Board. Today is Wednesday, July 21st. It is 9:01 a.m. and I would like to call this meeting to order. I'll begin by introducing my fellow board colleagues here with me today. Joining me is Board Member Sean McGuire, Board Member Laurel Firestone, and Board Member Nicole Morgan. Joining us as well as our Executive Director, Eileen Sobek, our Chief Counsel, Michael Laufer, our two Chief Deputies, Jonathan Bishop and Eric Oppenheimer. Our Clerk of the Board is Janine Townsend, and assisting her today is Courtney Tyler and Margie Argel. As you can see, this meeting is being webcast and recorded. We don't have a physical meeting room today to comply with, to respond to the COVID pandemic here. We will soon be transitioning into the building now that there is no longer a mask requirement. But for today, we are here on the virtual platform still, and you are either here joining us one of two ways. You're on the customary web stream online, or you are on the Zoom platform here with us today. And so if you are intending on commenting on any of our items today, you should be here on the platform. If not, there are instructions on how to do so on our website and on top of the notice of for today's meeting. But you can also email comment letters at waterboards.ca.gov, and the clerk of the board can help you get on the platform if you should need. With that, I think we can just move into what is, I think, our first and only item of the day. Item number 10 is being continued. And so we have item number 9 and would call folks up to, and one moment, I apologize. Since we are on a second day here, I just want to make sure that we don't have any public commenters, and no, so there's no public forum. So we can move on to our first item. And joining us as well is Vice Chair Doreen Diadama.
Chair, before we begin.
Of course.
In the abundance of caution, I will decline to participate in the board's deliberations on this item. More than 10 years ago and in a prior life, I worked to support some of the County of Sacramento's efforts on the Freeport project. This is the project and point of diversion that in part would be utilized by the change petition. I have conferred with Chief Counsel Michael Laufer, and the matters I worked on do not overlap with the issues in this change petition and do not require my recusal. Nonetheless, in an abundance of caution, I will not be participating in the board's deliberations on this item today.
Thank you, board member, and appreciate the ethical line there around it and the abundance of caution. So thank you. Mr. Lilly, good morning.
So yes, good morning, Chair Esquivel and members of the board. My name is Alan Lilly. I am the presiding hearing officer of the Water Board's Administrative Hearings Office, and I will be presenting this agenda item number 9 today. And with that, we can go to slide 2, please. This agenda item is consideration by the board of a proposed order on 2 petitions that were filed by Sacramento County and the Sacramento County Water Agency to change their water right licenses, which are listed here. Next slide, please. This is a little small, although you do have a larger version of this figure 1. This is figure 1 to the attached to the proposed order. And I just wanted to give a general location information on the project. It's a little hard to see in this figure, but in the top center part of the figure are the runways of the Sacramento International Airport and the other facilities. Right about midline, going horizontally through the figure, is Interstate 5. And then below that, kind of meandering around, is the Sacramento River. And of particular interest are the parcels that are in the current place of use, current authorized place of use for the 2 water right licenses. The ones with the sort of pink hatching are the authorized place of use for license 1062. The ones with the green hatching are the authorized place of use for license 4060. And just by way of background, the water rights that were confirmed by these licenses were perfected through diversions of water from the Sacramento River. I think the points of diversion are listed there or shown there by the rectangular boxes. So you can't read the numbers here, but in the figure, the numbers are shown. So the water was historically diverted from the Sacramento River at those points of diversion, pumped to the fields, used there to irrigate annual crops. And that's how the appropriative water rights were perfected and the licenses were issued. The first license issued in 1931, the second one in 1955. And I'll come back to that in just a minute, but we'll go on to the next slide, please. The proposal in the petitions filed by the county and the water agency would be to change the authorized point of diversion to the Freeport Regional Water Authority's diversion facility, which is shown in the just below center on toward the left side of the screen there, south of Sacramento, also on Interstate 5, but about 10 miles downstream from the existing points of diversion. And then water would be treated, pumped from the river at that point, and then treated and delivered to the zone 40 of the Sacramento County Water Agency, which is shown basically in the center and center right of this figure. The water would be delivered to customers there for municipal and industrial purposes, which would free up or reduce the amounts of groundwater that otherwise would need to be pumped for those uses. I will go on to the next slide, please. So as I mentioned, well, I didn't mention, but the application that ultimately led to license 10062 was filed in 1918, so soon after the Water Commission Act was enacted in 1914. And then after a permit was issued and facilities constructed and water diverted and applied to beneficial use, the license was issued in 1931. It has a typical irrigation diversion season, about April 1 to about October 1, at rates up to 7.44 CFS, and the authorized place of use I showed you in the previous figure. The second license is based on an application that was filed in 1951. After the permit was issued, facilities were constructed and water diverted and applied to beneficial use. The license was issued in 1955. Its diversion season starts on about May 1, goes through October 1, again, typical irrigation season, at rates up to 1.57 CFS, and the smaller authorized place of use that I previously showed you. I'll go on to the next slide, please. So beginning in the early 1980s, Sacramento County started purchasing various parcels south of the airport to protect aircraft approaches and departures. And these included purchasing most of the lands that are in the authorized places of use for these two licenses. I think there's one parcel that was purchased by the Flood Control Agency, but another a local public agency. In connection with that process, in 2007, the county did not renew the leases that it had been previously entered into with basically farming entities to irrigate those lands for agricultural production. And it was really primarily because of two concerns. One was just the concern about having unmarked, uncertain vehicles in the area, particularly after the September 11, 2001 terrorist attacks. And then the other concern from an FAA advisory was about attractions of large birds to irrigated lands. And by the way, I did just check, it's actually Federal Aviation Administration, still FAA, but I'm not, the exhibits we received said authority, but I just checked on the web and it's actually administration. So if necessary, we could make that minor correction in the order. But the big concern was large birds were attracted to irrigated lands, and those could fly up and basically be sucked into the aircraft jet engines. And we all know about the Sully incident from LaGuardia in that same era. So obviously there was a strong desire to stop the irrigation there. The county now uses these lands solely with no irrigation to protect the aircraft approaches and departures and for Swainson's hawk habitat mitigation. And there was testimony during the hearing that the Swainson's hawks tend to fly low. They're looking for mice, rat, and other rodents to eat on the land. And they apparently are, and there's much smaller birds than the geese that were of concern. So apparently they are not a concern for the aircraft. Next slide, please. So using historical cropping data, the county's expert witnesses made estimates of the historical diversions in use under these licenses. Unfortunately, but as often is the case, there were not good meter records of those historical diversions in use, something that the board and the Division of Water Rights have been working on, continue to work on to try to improve. But based on those estimates, the historical use amounts, annual amounts from the recent years of somewhat normal use, I'll say 2001 and 2003, the county estimated 859 acre feet of use under the one license and 106 under the other. And as I think I mentioned before, the last diversions in use occurred in 2006. Next slide, please. So the county, first of all, the county airport's personnel were not aware of the details of water rights, but eventually learned from discussions with Division of Water Rights staff that the water rights did have value separate from the value of the lands and potentially could be changed in a way that they could be put to beneficial use. I'd say the county's process really took off in about 2012 when they became aware of this and started seriously and diligently pursuing the petitions. They ultimately filed the petitions to change the two licenses in 2015. The petitions ask the board to approve changes in the authorized points of diversion, purpose of use, and places of use. As I mentioned before, when I was just showing the slide of the Freeport Regional Water Project Authority intake and Southern Sacramento County place of use. Next slide, please. After the division issued its public notice of the petitions, there were one set of comments and two protests. California Fish and Wildlife submitted comments. They were not in the form of a protest, but just comments, and they and the county later were able to resolve those. The two protests that were filed were by the Department of Water Resources, DWR, and the Bureau of Reclamation. And those, they did have some fairly detailed discussions to attempt to resolve those, but ultimately were unsuccessful. And so the matter was assigned to my office, and we held a hearing last August by Zoom teleconference on the two petitions. I will say, I think both, or all parties, all three parties put on very good cases, very well represented. And it was certainly very, very thoroughly presented, which certainly made it a lot easier for me and my staff to work on the matter. We prepared a draft proposed order, which we circulated in January of this year. We received extensive comments on the order, the draft order from Sacramento County and DWR. I did not receive any comments from Reclamation. We made substantial edits after our internal discussions, and we transmitted the final order to the clerk of the board on June 1. And incidentally, under Water Code 1114, our office normally has 90 days after a matter is submitted to complete our proposed order and submit it to the board. So we did meet that 90-day clock on the last day. And then the board has another 90 days from that date of transmittal to act on the order. We originally had set this matter for one of the August meetings, but Ms. Townsend moved it to this meeting because those agenda items are somewhat fuller, and we had time today. So next slide, please. So during the hearing, the primary issues were, as listed here, first of all, whether the board should revoke the licenses due to the non-use. There have been no diversions in use under them since 2006. And then if the board does not revoke the license, should the board grant the change petitions? And if it does, what terms and conditions should the board add to the licenses? So those were the hearing issues and the issues that are addressed in the proposed order. Next slide, please. So the proposed order discusses this in quite a bit more detail, and the agenda item has a summary of this, but the basic analysis is the board has the discretion to revoke these two licenses because there was non-use for more than 5 consecutive years when water was available for diversions in use. Discretion means the board may revoke or may decide not to revoke. The board can go either way, and the law is pretty clear. It's up to the board to decide what to do. We went into quite a bit of analysis of past decisions and orders of the board on license revocation issues, developed an analysis of the various factors that the board has considered in the past or did consider in the past in those decisions and orders, and ultimately concluded that the board should exercise its discretion not to revoke the licenses. Perhaps most closely on point is Order WR 2014-0021, which obviously the board adopted in 2014. And in that matter, the board decided to revoke a water right license that the Masonite Corporation had assigned to Millview County Water District for diversions on the Russian River because the Masonite plant had shut down because of economic reasons. It was a forest products processing plant. In that case, the board revoked the license. Here, our proposed order would have the board go in the other direction. And the primary distinction, as I've noted here, is that after board staff notified county and particularly county airports about the potential revocation of the licenses and the licenses value, the county and the water agency really did proceed diligently to prepare and file their change petitions, to complete the necessary CEQA documents, and basically to work through the process to the point where we are today. And it's very marked contrast to the Millview situation where Millview really just never exercised any similar diligence. They filed a petition, they actually had the wrong form, never corrected the form, never did the CEQA work, and just did not have any kind of similar diligence. So for those reasons, our recommendation, which is stated in the proposed order, is for the board not to revoke the licenses. The proposed order does have a section which would partially revoke the licenses down to the estimated diversion rates that the county provided for the 2001-2003 diversion rates as an initial step in the analysis. And then we go forward with the impact analysis for the change petitions. And incidentally, neither DWR nor Reclamation really challenged the estimated diversion rates. They did point out the lack of meter data and said there were some uncertainties, but they certainly never offered any alternate estimate of the amounts of historical use. Next slide, please. So if the board proceeds with our recommendation to not revoke the licenses, then the order would grant the change petitions. We would add new annual diversion limits, 805 acre feet for one license and 101 for the other. These are slightly smaller than the partial revocation amounts and the historical use amounts. And the reason for that is that the estimate is that with the proposed new use in southern Sacramento County for municipal and industrial purposes, the return flows would be a slightly lower percentage of the diversions than they were historically for the irrigation. So to basically prevent any impacts on the downstream water users, particularly the state and federal water projects, it's necessary to have those lower limits. The current licenses do not have any annual limits at all. So these would be new annual diversion limits that would be added to the licenses. And for similar reasons, the proposed order would reduce the instantaneous diversion rates so that, again, the return flows would end up, or basically the consumptive use would end up being the same and there would not be any injury. The proposed order does have proposed amended licenses attached to it. This is something in consultation with Mr. Ekdahl and Division of Water Rights, we've concluded was appropriate, basically to reduce the burden on the Division of Water Rights, which, as you all know, is quite busy right now with drought matters. We worked with staff, Division of Water Rights staff, on the form of the licenses and reached agreement. So if the board adopts the order, all Mr. Ekdahl has to do is sign the amended licenses. There's no significant additional division staff work. Of perhaps some interest is there is one term in each license that would require a detailed accounting by the licensee, the water agency, of all the water that's diverted through the Freeport project, and then an allocation of that to the various water rights that authorize different diversions, including these two licenses. Make those reports or those accountings available on request during the year, and then also submit them with the annual licensee reports each year. Okay, next slide. So our conclusions are that regarding the proposed changes, with these limitations on the diversion rates, the changes would not have any unreasonable effects on fish, wildlife, or other in-stream beneficial uses. They would be in the public interest, and they would not grant a new water right. Now, DWR and Reclamation asked that the board add standard term 91 to these licenses as part of the order approving the change petitions. But the order concludes, and we have a little bit of analysis on this, that the board does not have the legal authority to do that under the El Dorado Irrigation District court decision, which is cited here. That was one where the board added term 91 to a senior water right, I think it was a permit in that case, but had not added it to the many more junior permits and licenses that did not have term 91, and the court said that violated the priority rule. So consistent with that decision, the proposed order concludes the board may not add term 91 as part of this order. We do have a footnote noting that the board may in the future, if it does a comprehensive Bay Delta process, decide to add term 91 to all water right permit and licenses that are junior and priority to these two, and then also could add it to these two as well. Next slide, please. So in conclusion, for those reasons, I and my office recommend that the board adopt the proposed order. And of course, I will be glad to answer any questions.
Thank you so much, Mr. Lilly. I just appreciate the incredibly thorough and great work of your office as always, helping us ensure that we have consistent rulings from the water boards, but also, making sure we're leveraging the great many decisions that we've had and ensuring that we're continuing to care well for the water rights system here in a way that is fair, but again, create some consistency when it comes to the way we've made determinations here. So I just really appreciate the great care and work on this project.
Thank you.
We have board members, any questions off the bat? We do have two commenters that we can go to here as well. Okay, hearing none, we can hear what our commenters have to say here. First, I'd like to call up Aaron Ferguson, please.
Good morning. Apologize for the technical difficulty.
No apology in the least. Good morning. Good to have you with us.
Yeah, good morning, Chair Escobar and board members. I as well want to say thank you to the AHO's office for its time and attention to this matter and the very thorough order. Sacramento County very much appreciates it. Upon our final review of the draft licenses that are included with the proposed order, we noticed a couple of items we wanted to call out that hopefully can be addressed without much difficulty. In particular, in license 1062, it lists the priority date as August 29th, 1918. And I believe that should actually be August 28th, 1918. So hopefully that can be addressed. Additionally, in paragraph 5 of both draft licenses, where the diversion rate is stated, I believe the words "or foot" should probably be deleted so that it reads for example 4.09 cubic feet per second. And then similarly with license 4060, there is similar language that I believe should be deleted as well in paragraph 5. So and beyond that, if those two items are addressed, the county and the water agency encourage you to adopt the proposed order and the draft licenses in their entirety. Thank you very much.
Thank you, Mr. Ferguson. I appreciate it. When it comes to those edits, Mr. Lilly, are there any issues or question there?
I don't think so. Maybe you want to just take Mr. Soto's comment. I'll double check, but I don't think there's any controversy here, but I'll let you know.
Okay, thank you, Mr. Lilly. Yes, next we can take Eric Soderlund.
Good morning, Eric Soderlund, on behalf of the Department of Water Resources. I guess I'll be the lone objector to this order, but I just want to put forward that the Department does not support the adoption of the proposed order, mainly on kind of three grounds. We think that it gives too long of a leash, so to speak, on water rights holders as far as when you could resume use under a dormant water right. We don't think it's consistent with current practices, especially with transfers, and I'll kind of explain that a little bit. The second one is we believe that the order actually takes water away from public trust resources, which given the current circumstances is even more highlighted and more critical. I'll explain that a little bit. And then the last one is actually don't think that the order is consistent with past orders. In fact, the order that Mr. Lilly brought up before, we think is very relevant, provides good precedent for the board to follow. And the superficial, at least in my opinion, the superficial distinction of CEQA compliance, maybe more important in this order than it should be. And again, in 5 minutes, I won't go through the whole arguments, but I guess I'll go through those 3 points. The first one of the too long of a leash, it wasn't stated, but I think in your board materials, you probably saw that these water rights had not been used for over 10 years. The county of Sacramento was running an airport. They weren't interested in putting water to beneficial use. They made steps to further their interest with airports with no mind and no consideration for how these water rights licenses should be put to use. And it was only in the face of potentially losing them that they did anything about putting water to beneficial use. And again, I don't want to cast a negative light on the county of Sacramento. I've flown out of Sacramento Airport many times, and I appreciate the safety. But when it comes to good management, good husbandry of water rights, I don't think the county has met that level. When we talk about transfers, and the reason why I'm using the word transfer is because these change petitions are a new place of use, a new purpose of use, a new and a new user. The water agency is not the county of Sacramento; it's a new agency. So it's really very similar to a transfer. And in current practices, we do not allow transfers. The department doesn't look to facilitate transfers, and I hope the board wouldn't allow transfers where you haven't had use for the last 5 years or the last 10 years. And Mr. Lilly brought up the fact that the department did not provide other estimates of use is because we were talking 20 years ago. In no good transfer in current circumstances would we go back 20 years to figure out what would have been used absent the transfer. And so I just didn't want to, in a sense, play that game because I think it would have been nonsensical. And I think there's a reason why when you talk about revocation, when you talk about transfers, you don't go past 5 years because you start getting in really unsteady ground as far as knowing what that use would have been. So we think in approving the order, it just gives too much of a leash to future water right holders that they can sit on water rights, do nothing, and then come up with some use 20 years in the distant past and put that forward as a maximum use to be allowed in the new place of use, purpose of use. And we just think that that's not good water management. And then, going on that, then so what was that water going to in the intervening time? And the department will argue that was going to meet beneficial uses, was going to meet objectives set to help protect and support fish and wildlife in the Sacramento River and in the Delta ultimately. And that's especially true in conditions when the Delta was in balanced conditions. And so there's a rule, I guess, that I don't think the board has to use in this context, but it's the competing use rule that has been outlaid for revocation in the context of pre-1914 rights. But even if you wanted to apply it here, I think it's been demonstrated that public trust resources have had a competing use, especially when the delta's in balanced conditions. And so that's why the department puts forward the position that at the very least, these licenses should be revoked during conditions where the delta is balanced. We think that there's a competing use. We think it goes to meet those public trust resources. And again, in these current circumstances, as we've learned in the past drought and this current year, all the water is necessary. Even 900 acre feet can make a difference. And so we think revocation for periods of balanced conditions is consistent with the law. It's not applying Term 91, although Term 91, obviously is involved with that. It's not being queued. It's actually, applying the law consistently. And we think that that's in support of what the board's trying to do of getting water to meet public trust resources. And then lastly, we do think that the 2014 order where you revoke the license in Millview is very applicable and very similar circumstances and similar reasons for why the board could revoke the license here, especially for the period where the delta is in balanced conditions. And I think the diligence aspect, I think, is a little bit overplayed with CEQA. Millview was they didn't come off as a sophisticated water rights entity. They went out of business, as far as I understand. And so in the order, it seems like the argument was that they wanted to see if they could actually sell the water before they would do the CEQA, and I can imagine the economic reasons for that. But in this context, County of Sacramento had an almost 20-year-old CEQA document that they used to rely on, the Freeport EIR. And in really no way, and I don't want to get into the CEQA coverage because the department's not, objecting to or complaining about CEQA coverage. But we just don't think that CEQA really demonstrates a forethought or diligence to the extent that should overcome a decade-long absence of use under these water rights licenses and the harm that we believe that would occur to the public trust resources. For those reasons, we think that the order should not be approved, and we recommend that these licenses be revoked at least during the times when the delta's in balanced conditions.
Thank you very much, Mr. Sutherland. I appreciate your comments and the engagement here on this decision point for the board. I would like to hear a little more about the confidence we have when it comes to the net impact here for also public trust resources, but others in the watershed, other water rights holders. The fact that, again, that we're pegging their amount to what is less than the right because of the lack of return flows from the prior usage. And I know, the various analysis we did with the change in point of diversion, just how confident are we here that this can be accomplished without injuring folks in the watershed?
So would you like me to respond to that, Chair Esquivel?
Sure, Mr. Lilly, yeah, if you don't mind.
All right, thank you. And the answer is yes, we can be confident. Really, once the threshold question of whether the license should be revoked is decided, I don't think there's really much controversy about everything else. And I do have a very qualified senior water resource engineer on my staff who crunched all the numbers. He crunches numbers like nobody I've ever seen before. It's quite good at it. And he and I went through the analysis to make sure that we would have diversion limits so that the consumptive use amounts would not increase at the new place of use as compared to the historical consumptive use amounts for irrigation. And that is set out in the order pretty clearly. So I'm pretty confident that there will be no net impact on the downstream river flows. And of course, that its downstream river flows for both public trust resources and for operations by the projects. Now, this all is a little bit theoretical. I mean, we're talking about 5 cubic feet per second maximum diversion rate here. And I think everyone would agree there's no way that DWR and the Bureau of Reclamation can operate their projects to that level of precision. They operate in the order of thousands of cubic feet per second. The tidal flows in and out of the delta twice a day are in the order of hundreds of thousands of cubic feet per second. So this 5 won't be seen, but nevertheless, it is important that we do the analysis correctly, and we have. So I'm confident that with the diversion limits this order would add, there will not be any net impact on either water users or the public trust users. One other thing I forgot to mention before that I should mention, when we circulated the draft order for comments, we certainly got detailed comments from Mr. Soderlund, and we took them very seriously, of course. And we added a part 4 to the order, which summarizes each of DWR's comments and the response, our recommended response, which would become the board's response. So we have addressed these issues. I think at the end of the day, we just have a disagreement on the question of how the board should exercise its discretion. And we've made our recommendation here. I do think the diligence that the county and the water agency have exercised here is a major distinguishing factor from Millview and Masonite. And I guess the one thing I do disagree fairly strongly with Mr. Soderlund is on CEQA, particularly for a local public agency filing an application or a petition with the water board in a water right matter. One of the most important things they can do is get the CEQA document done. I mean, they're the CEQA lead agency. They do all the analysis, the environmental analysis. Of course, the board has to evaluate that and see if the board agrees from its water right point of view. But that is a critical factor for local public agency diligence. And I think the county exercised that here. So anyway, I hope that answers your question. I can go back to the corrections when you're ready, but I want to make sure I've first answered your question.
Thank you, Mr. Lilly. Yes, I appreciate that.
Should I just tell you the 3 corrections, or excuse me?
Well, I believe Mr. Soderlund had his hand up there for a moment, so I was going to see if he wanted to respond back a bit.
Yeah, I don't know how much back and forth you would like, Chair, and I respect obviously Mr. Lilly a lot, and in some ways this is, in that respect, this is just a difference of opinion on what should happen. But I think there's a little bit of a casual disregard to how little the diversion rate is and the amount. Yes, it is a drop in the bucket, but I think you're going to see in this, in times like this, in years like this, that DWR's compliance, even though it's averages, the compliance is going to be razor thin. And 900 CFS could make a difference as whether you're above the line or below the line. Obviously, DWR operates to stay above the line and would do our due diligence to do that. But you can make a difference, especially in very critical years like this, where 5 CFS could matter whether the objective was met or not. And I think more importantly, it's the principle that, again, if you're assuming that the water was used consistently, then the distinction between, the change is not significant. And I agree with that. But what we're looking at is these water rights were not used. They were not put to beneficial use. And the record of their historical use is very sketchy at best. And in a large part during the time that Sacramento owned the water rights. There's just a casual disregard to know and to use these licenses. And so what we're looking at is the distinction between zero use and the change petitions. So with that,
I appreciate it. Thank you, Mr. Sutherland. All these discussions for us here are about actually getting to the heart and going back and forth around these issues. So I appreciate your comments here. Board members, any questions or thoughts?
Yes, I have a question for
Vice Chair, please.
Mr. Soderlund. So on the issue of the term 91, I'm hearing you say that you don't believe that it would be a term 91, that we have authority to prevent those diversions when the delta is in balanced conditions. But I'm just, I can't tell if you're suggesting that that would be part of the process for determination of revocation, or once we get to the conclusion, as I read the decision, as to whether or not the license has been revoked, then what remains is whether or not we could impose term 91, which I don't believe we have that authority. So I just want to better understand your thinking here.
Yeah. You know, I know that I can say this as DWR, and so I understand that maybe the cringeworthy aspect. I do believe the board has the ability to apply term 91 in this context. I know El Dorado, and I know a lot of people would come out of the woodwork, so to speak, to argue against this. But I think El Dorado has some openings for the board to take, especially given unusual circumstances and especially issues of great importance. And I think the public trust resources was actually one kind of identified. And so in this context, I think the board could say, you know, given current circumstances of where public trust resources are and where we are with trying to get more water into the system, and the fact that these licenses have not been used or relied on for a greater part of 10 years, given all those circumstances, we think that the public interest in applying term 91 can trump or normal circumstances of priority. Now, would that stand? I don't know. I know that's probably not what the board wants to do. And I think that because of the current circumstances, there's a great alternative to it. And it's not being queued. It's really relying on water law. It's relying on how revocation works. These licenses were not put to use for greater than 5 years. And if you want to apply this competing use principle, you could look to see, well, was this water put to use elsewhere? And I think you can argue that it was used to meet in-stream flow objectives. And when do you know that water would have met those in-stream flow objectives? And my argument, or the department's argument, is that when the delta is in balanced conditions, because there's not enough water to meet all of the uses. So the department and reclamation have to release stored water to help meet those objectives. So there's not enough water in the system. So that by default, that water had to go, unless you could say other people used it, and no one's coming out of, no one came out and said we used it, they raised their hands. And so I think by default, you could argue that public trust was using it or relying on it. And in that context, I would say that you have your competing use, you have it for 5 years. And so the board could revoke the license's ability to divert when the delta is in balanced conditions, because that water was used already and used for greater than 5 years. And under current water law, under your authority, you could revoke for those purposes.
Vice Chair, anything further?
Well, then I guess I'll turn to Mr. Lilly, because for me, the question, these two questions are separate. First of all, whether or not the license should be revoked. And I'm reading here on page 32 and 33 of the decision, the factors, Mr. Lilly, that you and your office analyzed, which I am comfortable with. I think that the issue of public trust when the delta is in balanced conditions is a separate issue, and I don't believe we have that authority. Now, perhaps these are good policy arguments, and we should consider an approach like this in a broader context. Perhaps, we may get there next year when we talk about how to address some of these broader curtailment issues. and really using that as an opportunity to look at the El Dorado case and whether or not there's some flexibility there. But for me, I'm uncomfortable about being creative in this case. And so I just want to hear your thoughts, Mr. Lilly.
Yes, and I certainly agree. The conflicting claim issue, as you pointed on page 32, the proposed order does talk about that, and the order agrees that there were conflicting claims. There's no dispute between DWR and the AHO on that issue, that there were conflicting claims for this water during the period of non-use. That's one of 5 factors, and the proposed order concludes, in exercising its discretion, the board should not revoke the license, considering all 5 factors. But yes, to answer your question, once the board, or if the board decides not to revoke the licenses, then I think the El Dorado decision is pretty darn clear that the board may not adopt or add term 91 or something like term 91 to just these 2 licenses. But you also are absolutely correct. Nothing in either this order or the El Dorado decision would prohibit the board from going back and doing a comprehensive review of the Big Delta and potentially broader curtailments. And we've made that clear in this order, and that's absolutely true.
Mr. Soderling?
Yeah, if I may, I just want to clarify that I do believe that there is a distinction, and in my mind, it's an important distinction between the AHO and the order and what the position I'm putting forward. And that is that the AHO and the proposed order says that the department used the water to meet the objectives, and that's not the case. The department does not use natural flow or abandoned flows. It relies on them, it accounts for them, and then to the extent that our responsibility engages to help meet the flows is when they're not sufficient to meet those objectives. So but that distinction, even though it seems minimal, it's very important as far as the implications, because if the department was using that water, then taking that water away is not a big deal because we're a junior water right holder. And in order to protect our interests, you apply term 91. And so you have the rule of priority, and it gets very complicated, and I can understand why the board wouldn't want to go there. But if the public trust resources were relying on the water, this abandoned flow was going to meet the objectives that the board itself stated that this is what Fish and Wildlife need. This is important to keep these in-stream flows. If that's where the use occurred, and your own decisions, and I believe even court decisions say that public trust resources, in-stream flows can be considered a competing use, then that's the use that you're taking the water away from. Now, the department obviously has an interest because of our responsibility. We got to backstop any water that you take away. So we have an interest in this, and one that the board itself recognized in the 2014 order, that releasing stored water to meet these objectives is an interest that can be protected. But that's not the point of the argument. The point of the argument is not to apply term 91. It's not to protect the department's stored water. What it is to protect the in-stream flows that are necessary to protect fish and wildlife that the board itself has said. And taking that water away is a harm to that. And that's why I'm saying the competing use is the in-stream flow itself. It's not term 91. And I know it seems conflating, and I know it seems like it might be cute, but it's a very important distinction. We're not messing with water right priorities here. We're not talking about term 91. We're talking about a lack of use that gives rise to the potential for revocation. And one of the potential issues you could look at is, was there a competing use? And in the case, especially when balanced conditions were applied, I believe there was a competing use.
Thank you, Mr. Soderling. Mr. Lilly, please.
We have been through this argument. I just want to note that the proposed order on pages 58 and 59 does address this issue. I think Mr. Soderling has articulated very clearly, but we just disagree. It's a commingled supply. The water goes down into the delta. Some of it goes out the delta. Some of it's diverted. And it's you can't really identify, well, this water went out and this water went to the, if you put in another 5 CFS, you can't say where that goes. It goes into a commingled supply and it goes out in different directions. And I think we've addressed that in that text, so I won't say anything further. But we just disagree with Mr. Soderlund's argument on that.
Yeah, I'm here with the vice chair, really feeling that these two issues are somewhat separated out here. There's the question of the revocation certainly, and that being determined, and then how to continue to be protective. And I think it's part of a larger policy discussion. This board is in the middle of the update of the water quality control plan update. Is very interested in protecting public trust resources and stream flows. Is this the moment or an ability here for us to ensure that that's the case? It's difficult to say that we have either the clear ability to do something like a term 91, even if we're using again other sort of justifications here. So I'm with the vice chair here. These are two somewhat separate issues. Although certainly there's overlap here when we talk about how we ensure that this decision isn't really impacting and harming public trust resources in a way here. But to Mr. Lilly's point here, the water isn't colored as public trust water right now. It's not protected as public trust water, and it isn't. And here again would have great difficulty to say that. Us acting differently than what's proposed by the AHO would be then that protective, or even I think here an option that we have really. So other board members though.
Yeah, I just want to say I concur with both you, chair and vice chair, on the policy issues as it relates to public trust protection. These are very important issues we do need to address soon. And so in my mind, though, teasing that out here with this particular order is not going to be a productive way to address that issue. And I just want to flag that, a lot of this can be colored by what we're facing this year and the challenges that we're up against now. But there's already been a finding by Division of Water Rights staff that water is unavailable for all post-1914 water rights this year, including, I believe, these water rights in particular. So, there's no water for these water rights this year. We're in a drought. It's historic. And those are challenges I'm trying to keep a little bit parsed out from this decision. And so then on the issue of revocation, when I look at that, I take that seriously. I do think, abandonment, forfeiture of water rights is a serious matter. And so I carefully read through the order and, ultimately, appreciate the fact that there is some discretion here. Because 5 years, that's the legislature acting, and certainly that's a reasonable period of time. But there are other factors to consider, and so for me, it was really important to see that the county did exercise diligence, and they did. CEQA is a huge challenge in many water rights issues. I used to work in water rights. I used to process water right change petitions. That is a barrier, actually, and so the fact that they relied on a larger EIR, but they also did a supplemental CEQA analysis for this specific project, for me, shows that they were exercising diligence in this case. And so for me, the other factor is just that this is not setting precedent. This is not saying that, anytime a party comes and it's been 6 or 7 years since they've diverted, it's a boilerplate approval to say that your change petition will be granted. No, that's not the case. We look at the facts here. That's what I believe the AHO did here. I looked at the facts. That's why we ended up with a 60+ page order analyzing these issues. And so for me, just taking the specific facts on this case and this water right change, I believe that the conclusions of the order are appropriate. So I think I'll leave it at that. I don't have any other questions.
Thank you, board member. Any further discussion here?
Yeah, I mean, I understand those comments. And I think what I'm struggling with is the, you know, and maybe Mr. Lilly can help clarify some of this for me, but to me, you know, I do think public trust and in-stream flow and sort of water quality standards are certainly a competing use and potential injury. And I'm just trying to understand how we would say there would be, I mean, I understand this is a very small amount of water in this case, and it may be hard to tease out a very small amount of water, but sort of on principle, it seems like this is, I guess I'm just not following how there wouldn't be some injury to public trust resource, or, you know, public trust water rights interests in this case. And so if you can help tease that out for me. And, you know, it seems like those are pretty clearly competing uses. And if we don't revoke, then those will be impacted. So I'm just having trouble teasing out why that's not the case.
Okay. Well, of course, I think the most important thing you said was this is all theoretical. I will stand by my prior comment. There's no way you can find 5 CFS in this delta. But in theory, if the board grants the petition, adopts the proposed order and grants the petition, then Sacramento County, at least when there's not a curtailment order, like as Board Member McGuire has pointed out we have now, but at least there would be some times that the county could divert that additional water, the 5 cubic feet per second. But that would not change the amount of water going out the delta because DWR and the Bureau still have to meet all of the water quality control plan requirements, which are incorporated into their water right permits. So the net effect, to the extent you actually could tease out 5 cubic feet per second, is DWR and the Bureau together have to do one of two things, or both. They can do a combination. They either have to reduce their diversions from the delta, or they have to release a little bit more stored water to make up for that 5 CFS. So one way or another, the ultimate impact is to their water supplies, not to the public trust uses. And I'm afraid that, oh, there you are, you're back. You disappeared from it. But anyway, so that is how, and that's what we tried to explain on pages 58 to 59, that ultimately the impact is on the project water supplies, not on the public trust.
Thank you, Mr. Lilly. Mr. Sutherland, did you have your hand up, or you're good?
You know, I'll give it back to the discussion. I think, you know, that goes back to the broader policy and legal argument. I think everyone's well versed. I don't know if I need to articulate it. If you like me to, I will, but I'll.
That works. Thank you, Mr. Sutherland. I appreciate it. Thank you. Well, unless Board Member Firestone, I'll let you continue your thread of question here.
Yeah, I mean, I wouldn't mind hearing your response. That'd be helpful.
I think, again, if you're looking at that the competing use was the public trust, and if that's the basis, then I think the department has a protectable interest here because Mr. Lilly's right, we have to backstop. And so, you know, if you make the distinction where the public trust was using it and now you're taking it away, that ultimately does harm the department because we're in the Bureau, because we'll have to release or make up for that water. And again, I know we're in theory, 5 CFS likely won't break the bank, but I do agree that it could be very razor thin, especially on years like this. But I think that so that brings up the broader policy and legal issues that I think what we're seeing is that, you know, this over-reliance on reservoirs is becoming defunct in this new way that the water's fallen and the new way the water's flowing under climate change, increased use, that sort of thing. That what this order does in principle is continue that over-reliance. You have the ability to step up and protect the water, the public trust. You have the ability and the discretion to make a stand and say, this water is for public trust resources now. And if you decide against it, again, I understand all the reasons why, and I've read the order too, and Mr. Lilly's very well versed, obviously. And the board, you all are well versed in all these issues. But to me, there's an argument that it runs counter to what the board's trying to do ultimately, because it just continues the over-reliance on the department. Oh, you didn't use the water right for 10 years. That's okay. We want you to use it, and any kind of deficit that results of that, that's okay because the department's going to make it up. And I know that's not exactly what you're saying. I don't want to put words in your mouth, but I think there's an argument. I want to put that argument forward that that's one way you can characterize it. But I don't want to overstate the issue. It's hopefully I'm being fair. Hopefully you guys are appreciative of this viewpoint that I think is important to consider.
So, and I just want to make sure I understand, Vice Chair, and Chair, what you were saying. So are you saying that in if we separate the two issues of revocation of the license and then the actual petition term and license terms granting the petition?
No, sorry, I'll just stop there first. At least when I think we're thinking about this, it's the revocation, but then the issue of ultimately a term 91 thing that can be applied to, if we don't revoke and, decide to not, that decision being on its own, what are the options there to ensure that, when the delta is in balance, that, again, not unlike term 91 applied to other water rights, that here there is some protection from what is then, the need for the project staff to release additional in this case. But the issue, of course, is that, we can't reach back and apply term 91 to a more senior right without touching the junior rights. It's why, again, and I, on the policy side, Mr. Sutherland, I agree with you. The deal that was struck in the 90s to say that the projects alone are meeting water quality standards in the Delta, when the Delta is 40% of the state, not really the greatest policy decision. It's why this board has been pursuing updated water quality control plan update. We're not going to fix that here in this decision. And it's not contrary to then the board's policies and its intent in that greater project or our work generally. But point taken, and I'll kick it back over to the board member. But that's where the sort of difference was there.
Yes, okay. Sorry, Vice Chair, did you want to add to that?
Well, what I would just add is that I agree, this is an important policy that we definitely need to grapple with, but maybe Mr. Lilly could also help by walking us through the El Dorado decision, because there was an attempt to do something like this with a handful of water rights. And because in that case, we didn't follow the water rights priority system, either looking at it from a comprehensive basis or just following the water rights priority system. That's why, it went up on appeal and we were reversed. I just think as important as it is for us to eventually grapple with this, not today, but whether it's water quality control plan or some other vehicle, I also think in the meantime that it's important to follow the water rights priority system because of the message that sends to the community at large. And again, not with respect to this decision in particular, but just looking at the actions that our board takes, whether it's curtailment or some other process, that we are committed to following the water rights priority system.
Right. Okay. So, and so that's all helpful clarification. So I guess I understand and agree with the idea that we can't just impose term 91. And what I'm trying to understand is when we're considering whether to find even partial revocation of the water right. I mean, this is a really long time that they didn't use water. And I think I think the order is right that a lot, there was a lot of due diligence here, which is an important factor. It seems to me another important factor is sort of the competing uses and public trust resource objectives, ability to meet objectives. And I'm just wondering, if I think there was another piece where we were, maybe I'm misunderstanding this, but where we looked at the partial revocation for how the return flows, sort of factoring in the return flows and lack of return flows. And I'm just wondering if in that space, how we are balancing, not just these issues of, we have a lot of discretion here, right? In terms of revocation of a license that wasn't used for more than a decade. The factors that we use here, certainly, I agree with the due diligence, but I just want to understand the competing factors here on, again, I know this is a tiny amount of water, but just because I think even though we say this isn't precedent, I think it does set a message of what we consider and balance. So I just want to understand how we are factoring that in with this first piece of, partial revocation. And maybe I'm sort of misunderstanding process here, but can you help with that, Mr. Lilly?
Chair Esquivel, should I respond to that? I'm not sure where I fit into this back and forth, so I don't want to interrupt.
Yes, by all means, please. Yeah.
Okay. So first of all, partial revocation is really a totally separate thing. And the Water Agency does not dispute that, because even their historical use before they stopped using water at all was less than the full license amount. So they have not challenged the board's, as an initial step in the analysis, to partially revoking, reducing the licenses down to the amounts of historical use. So that's sort of a separate issue. But the conflicting claim, I mean, the bottom line is that is one of the 5 factors the proposed order talks about on pages 32 and 33. And it's, Mr. Soderlund is absolutely right. During the period of non-use under these licenses, there was a conflicting claim. Now, he says that water went out the Delta. I think as a practical matter, that water went into the Delta and it could go in a lot of different directions. And the bottom line is that meant DWR and the Bureau did not have to release additional water from storage, to make up for that 5 CFS while it was not being diverted, or they could divert that much extra water from the Delta. And that's certainly a competing claim, but it's a competing claim under junior water rights. There's no doubt about that. So at the end of the day, that factor militates in favor of revocation, but the diligence factors, the plans for future use, and the factors beyond the licensee's control, here the FAA getting involved, militate against revocation. So it's a balance, it's discretionary. I've done the best I can to lay out all the factors the board's considered in prior orders and then to apply them here. But this is something that drives the engineers crazy. You can't just put in a number into a formula and come up with a result when you have a discretionary thing. It's, you're a lawyer and I'm a lawyer. It's balancing competing needs. And at the end of the day, it's a discretionary thing and you have to factor them in. So I hope that answers your question. That was the analysis.
Yeah, that's really helpful. So that's where this, I guess, what I understand then is partially it's a question of do we understand the injury, I guess, to be on DWRs, you know, these more junior water rights holders, or on public trust resources. And I think what we're saying, or what you're saying, is it's well, you're certainly saying it's on DWRs and these more junior rights holders in terms of any, I guess, I don't know that injury is the right word, but in terms of impacts.
Impact. I was just going to say, it's an impact on the junior water right holders' water supplies at the end of the day. The public trust resources will be met, or requirements will be met either way, you know, assuming that DWR and the Bureau meet their standards. So the ultimate impact is on their water supplies. And that as junior water right holders, that's a consequence they're taking. As Chair Esquivel said, the board maybe should and will go back and reevaluate that in a broader Delta context. But with the system we have right now, it's an impact on the water supplies of the junior water right holders.
And just so following that through, so in years where it's in balance, then it means that more water, you know, the projects need to release more water. There's less water and storage for cold pool and issues like this, where it's not just flow, but there's temperature. Go ahead.
Either that, or they have to reduce the amount of water they divert from the Delta.
And that's where it's the junior water rights holder diversion, right?
Yeah, well, either way, it's the junior water right holders' water supply. It's either they release a little more water from storage, or they divert a little less from the Delta, or some combination.
Yeah, I mean, I do think, to Sean's point, I'm certainly colored by this year because it's so extreme. And I think, you know, I think it's a good point that we have, you know, water unavailability and curtailments in this, well, we're soon to have potentially curtailments in this really extreme water year. But even before we got to that point, we were having temperature impacts because of lack of storage and having to release water to meet water quality standards. And so that does impact public trust resources pretty significantly. But I think what I'm hearing you say is that there's the ability for the projects to manage storage and temperature. They have a number of options, and this you know, I think I'm just following through maybe too many steps that are not directly impacts from this water use to public trust resources, because there's decisions on how the projects operate that could change what the public trust impacts are. These sort of indirect public trust impacts are from leaving this tiny bit of water in the system. Is that, I mean, I'm trying to, I think what I'm struggling, or not, what I'm trying to tease out is this year, you know, at this point, we're in a really extreme position, but even earlier this year, there were, you know, pretty direct impacts on public trust resources for not, for having to force, you know, the projects to meet water quality objectives and having less water in the system. And so I just, again, I think what I'm trying to do is understand the distinction between whether these are impacts on public trust resources versus impacts on junior right holders, and how we make that distinction, which seems much more much fuzzy, less. The only reason I think I have a harder time this year really separating the two is because it's so clear this year that that, you know, there wasn't enough water in, you know, in storage and in the system to be able to meet water quality standards and temperature to protect public trust resources. So I don't know. I think, can you help me just walk through how we're distinguishing? Again, this is, I'm sure this is in the order, and I did read the order, but just helping me parcel out how we are determining that this is, that not revoking this license is just impacting, would just impact junior water rights holders and not public trust resources.
Well, I'll try. I think the problem is that the Delta issues are so much bigger than this proceeding, this water right proceeding. There really isn't a whole lot of overlap. I mean, the Delta issues are huge. You all know that. You're going to have to deal with that. As Board Member McGuire points out, if there's a curtailment order for all post-1914 rights, then even with a change petition, Sac County can't divert under these rights. And that seems to be imminent in a very extreme year like this year. But separate from that, I mean, it really is here a case of, if the board does not revoke the licenses, then a senior water right holder gets this roughly 900 acre feet per year to divert. And that ultimately comes out of the projects, either their reduction, they have to reduce their diversions from the Delta, or they have to release that much more water from storage. So it comes out of a junior water right holder supply. I mean, I think it really, for this proceeding, it's really that simple. And the bigger Bay Delta proceeding really is a separate thing.
Yeah, okay, that's really helpful. I am following that. Okay, yeah, thanks for just taking the time to flesh that out. I think that really helps me. I certainly agree with, you know, the idea that we have to deal with the term 91 in a larger proceeding, that Bay Delta and, you know, control plan and in-stream flows and public trust protections are a whole separate, well, need to be addressed more comprehensively than just in, you know, trying to piece into this, this particular order. But I do really appreciate being able to just understand the through line of how we're assessing and balancing impacts to public trust resources within the system we have now without that more comprehensive piece. So anyway, this was really helpful. Yeah, I don't think I have more questions on that. Let me just take another look. Yeah, no, I don't have more questions, but I know you were going to say, I think, weigh in on the change requests or the wording change requests.
Yeah, so Chair Esquivel, if it's appropriate, I've checked my notes here. I have 3 recommended edits to the proposed order. which obviously, if the board approves the order, we will work with your clerk to make sure that they happen. And they're really all pretty darn minor. On page 5, in about the I think it's about the 8th or 9th line down, the proposed order says Federal Aviation Authority. As I say, that's my bad. It's actually line 7. It says authority. Should be administration. My excuse is I think some of the exhibits said the wrong thing, but I just looked it up. It's administration. So I recommend changing authority to administration there. In the license, the first proposed amended license, this is Appendix A to the proposed order. In the first paragraph, the priority date, it says August 29, 1918. It should be August 28, 1918. I don't think that's ever going to make a difference in implementing the license, but we want to make sure we get it right.
You know, there could be someone there. You never know.
If somebody filed on that day.
On that day. Okay.
And then in term 5 of each of the proposed amended licenses, Appendix A and Appendix B, Mr. Ferguson is correct. This was my drafting mistake, but it says cubic feet or foot per second. The or foot should be deleted. So it just says cubic feet per second. So just delete or foot in each of those two term 5s. So those are the only 3 recommended edits we have to the proposed order. And with that, we recommend that the board adopt the proposed order.
Thank you, Mr. Lilly. Board members.
Are you prepared to receive a motion, Mr. Chair?
I think so. Looking here to the rest of my colleagues, if there's any further discussion, I really appreciate Mr. Sutherland and Mr. Ferguson, your time here and the engagement and the back and forth around this. I appreciate just these are not easy issues. And I know that we want to be consistent and reflective of our priorities here in all of our decisions. I don't think this is a case of us being inconsistent, certainly with our desire to protect public trust resources and the fragile balance that we have within the watersheds. But I appreciate the points that DWR has brought up. Again, I think that you've heard here policy discussion with us around what that larger need and project is, and we agree. And so I think on that, we can continue to have discussion on how we ensure that things like the water quality control plan update are updated, but importantly, that we see an appropriate share of the public trust obligations across this 40% of the state that is the Bay Delta watershed, and not just be left to projects that we can see, particularly in this year, how difficult it is to accomplish everything. So I appreciate it, and we'll entertain a motion.
Well said. And with that, I propose adoption of the order with the changes that were read into the record by Mr. Lilly.
Thank you, Vice Chair. Thank you. Ms. Townsend, can you please call the roll call vote?
Yes. Vice Chair Diadamo.
Aye.
Board Member McGuire.
Aye.
Board Member Firestone.
Aye.
And Chair Esquivel.
Aye.
Thank you.
Thank you as well. Motion carries and the item is adopted. So thank you all. I appreciate it. And thank you, Mr. Lilly. And again, Mr. Sutherland and Mr. Ferguson, and my board colleagues here. I much appreciated.
Thank you.
Thank you. That concludes item number 9 and actually concludes our board meeting for today and this week. I know we have a closed session on the calendar. I believe that was in case we needed to further deliberate on any of these discussions. So I believe we will not be having a closed session. Just checking with our Mr. Lawfer here if there's anything further that I should make sure and address before formally end this meeting.
No, there is nothing further from me.
Okay. Thank you, Mr. Lawfer. Thank you, board colleagues and everyone for your time today. And we will be here in 2 weeks. We'll see you all next August 3rd, and really appreciate, as always, everyone's engagement and time today. So have a great week. See you all soon. Take care.
Bye. Thank you.